Hey folks, I'm attorney Roger P. Foley. I'm driving in the car this morning, and yesterday did a video on 3 things you shouldn't do, and one of those was writing a letter to the judge. So I immediately got feedback from some followers, and I appreciate you following. Hopefully I give you some information that's worthwhile to you. But I wanted to make the distinguishment. When I'm talking about writing letters to a judge, there's 2 types of letters that people write to a judge. The first is, oh, I'm innocent, or this isn't what happened, or the police officer got it all wrong, or the victim's lying, or I wasn't there. It's an excuse letter, or a have mercy letter, maybe written by a parent or a loved one. Those letters are not read by the judge. The judge opens it, goes, yeah, I can't use it. I'm not allowed to have a third-party contact. And he instantly tosses it over to his secretary, his judicial assistant, and says, look, send a copy to the public, send a copy to the state attorney and send a copy to the defense attorney, whether it's a private or a public defender. That's the letter that I'm talking about that the judge doesn't use, and he tosses it to the side. There's another type of letter. That is, after you've either pled guilty or you've been found guilty by a jury of your peers. What happens then? A lot of times there's a pre-sentencing report done by the Department of Corrections. Your attorney can waive that, or they'll go through the motions. A lot of times in that type of situation, the defense attorney will ask for character letters, or family members or loved ones, or maybe a boss. I can tell you from experience that having people in court to give character testimony from a sentencing perspective is better. So when I talk about the 2 types of letters, again, the character letter, I got to tell you, it's not that beneficial. But, talking about the impact it has on the family, if it's a real serious case, obviously if someone's charged with murder and they pled guilty to murder, or they've gone to a jury trial and they pled guilty, I can tell you that the character letters aren't going to help. The judges are going to be like, oh my goodness, he's such a nice young man. He just happened to kill these people that last year, and I was just one bad thing, but he's got all this good stuff about him. Yeah, doesn't happen like that. Character letters are viewed by the court. How much importance are they given? In my humble opinion, not very much, but you still do everything. Even if it helps 1%, you do it, right? So, but I'm not a big guy on character letters, because I'm not a big guy on trying to think forward with negative energy that I'm going to lose a case. So when clients come in, even on serious cases, and say, hey, Mr. Foley, should I get you some character letters? My pastor write a letter. My job is going to write a letter. My mom and dad, I happen to know the governor. Yeah, it's all great. But you only need that letter if you lose, or if you plead guilty, right? If you go to trial and you lose, then you probably, if you know the governor, you probably want to get him to write a letter. If you know the Pope, well, that'd probably be a great letter too. If it's your friend Johnny, how much input or how much of an impression is that going to make on the court? Listen, again, my humble opinion is it's not going to make a lot of difference if you've already been convicted of a crime or pled guilty to a serious crime. On lesser crimes, one woman wrote in and said, hey, my son had some drug charges. He was facing 5 years in prison, and I wrote a letter to the judge asking for rehab. Well, your attorney, his attorney probably could have done that, and maybe your letter helped. And I'm glad that your son was able to get a 90-day rehabilitation sentence. But generally, I can tell you from doing this for 16 years, when mom and dad write a letter, when the defendant writes a letter and the case is pending, the judge doesn't look at it. It's an ex parte communication, and the judge cannot look at it. He literally hands it to his secretary, says make copies and files it with the clerk of court. So the defense attorney gets a copy, the state attorney gets a copy, and the clerk, files it up on the docket so it goes into the court file. The judge isn't reading it because the judge can't read it. So the characterization letters after sentencing, they do help a little bit. But how much, you probably have to ask a judge. I've never seen someone be convicted of a crime, be looking at a prison sentence, right, especially on a felony case, send a good character letter by friends, family, and maybe people of importance, and the result differ. It just doesn't, folks, right? You see these character letters on real serious crimes, murder, rape, arson, life felony, shooting cases. I just don't think the judge is putting that much into letters from friends and family because they're biased, right? They're subjective. They do listen to victim letters because there's a victim impact. So I think those letters hold more importance for the court. But anyway, I just wanted to make the distinction. I was just looking at some made on my video, right? And you pled guilty or been found guilty by a jury, don't write a letter because the judge doesn't care. Crumbles it up, tosses it. If and pled guilty to the charge and are awaiting sentencing or have been found guilty by a jury and are awaiting sentencing, then you can write those letters, or more importantly, appear for your loved one in court to give that testimony live, and maybe write a letter and read it from it and give the judge the copy of it. Anyway, I'm attorney Roger P. Foley. Letters to the court explained. If you didn't know, now you know.